I'd like to mention for listing of a motion matter, newly filing day before yesterday, I have filed on Tuesday,
Wednesday.
On Thursday,
Maybe lordship. I beg to mention for listing lordship. Preparation lordship. In admission column lordship after vacation lordship.
You have to go to the register and enter into the registry.
May I please the lordship. Lordship, back to mention item number 9, lordship. Lordship, conducting counsel is not well, lordship. Any other day, lordship.
These are all connected.
Yes, lordship. Same implement for of parties, lordship. It is in order column. But he is not well today.
Prayer for adjournment has been made on behalf of the writ petitioner, on behalf of the petitioner applicant, on the ground that the conducting counsel is unwell and therefore has not been able to come to court today. Having regard to the ground on which the prayer is made, the same stands alone. Let these matters be listed again after 3 weeks.
May I please, Lordship? Lordship, I'm praying for withdraw and read petition, Lordship.
You are
Item
praying for?
number 4. Item number 4, Lordship.
Item number 4.
Yes, Lordship.
What do you want?
Lordship, may kindly allow us to withdraw this read petition.
Withdraw.
Yes, Lordship. And to file FS read petition.
Why you want to withdraw?
Lordship, there is a office memorandum.
Hmm.
Uh, 6/8/2020, Lordship, which we have to challenge here, Lordship. Therefore,
Your name, please.
R. Methi.
Miss R. Methi, learned counsel for the petitioner submits that some vital document has not been annexed to the writ petition, as a result of which she has instructions to withdraw the writ petition with liberty to file afresh. The prayer is not opposed by the respondent's counsel. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for.
Obliged, Lordship.
Hearing this promotion, item 1.
May I please the lordship?
Yes.
In this case, lordship already passed the similar order, lordship.
Lordship, may I just want add one line, Lordship. If he is not getting the adequate pension, then Lordship, the authority may examine, Lordship. If he is not getting adequate pension, then our authority will pass order.
Lordship order, lordship.
Take that. Heard Mr. C. Bhattacharya, learned counsel appearing for the writ petitioner. Also heard Mr. N.
1, 4, and 5.
Upadhyay, learned standing counsel, irrigation department, appearing for the respond numbers 1, 4, and 5. Mr. R. Boro, learned counsel is present on behalf of the respond numbers.
6.
6 Attaragudigo, Mr. A. Chakravarti for Government Advocate Assam.
Number 3, Lordship.
For 3 Attaragudigo, Mr. B. Gogoi, learned additional AG Assam. For respond number 2. Anything you have to say, Mr. Gogoi? Do you have anything to say?
No. It's covered.
The case of the petitioner is that he was initially appointed as casual master role worker in the establishment of executive engineer, Dhubri Division Irrigation on 10/2/1992, and his service was regularized as grade 4 chokidar with effect from 22/7/2005. Wide office order dated 6/10/2005, issued by the executive engineer, Dhubri Division Irrigation close Goripur. The petitioner had retired from service on attaining the age of superannuation with effect from 31/1/2024. although the petitioner has rendered the requisite qualifying years of service, the authorities have not paid him adequate pension. Hence this writ petition system. By referring to the decision of this court rendered in the case of Sanjita Roy versus State of Assam and others, reported in 2019 bracket 2019 bracket plus 2 GLT 805. Mr. Bhattacharya submits that law is now settled that the 6 years of service as casual worker is required to be added to the length of service of the petitioner, in which event he would have crossed 20 years of qualifying service. First of all, notwithstanding the same, the respondents have not paid him the full pension. First of all, contending that the petitioner's case is covered under the decision of Sanjita Raj Supra, Mr. Bhattacharya has prayed for issuing a writ of mandamus in this case. First of all, Mr. Upadhyay, Learned Departmental Counsel, submits that the issue is covered by the decision of Sanjita Raj Supra. First of all, however, the petitioner's claim would have to be verified before enhancing his pension. Similar to the stand of the learned counsel appearing for the other respondents. In view of the above, this writ petition stands disposed of by providing that the case of the petitioner will be considered and processed in accordance with the law laid down in the case of Sanjita Raj Supra, after carrying out necessary verification as to whether the pension given to him by the authorities is in accordance with law or not. Full stop. The aforesaid exercise will be carried out within a period of 8 weeks from the date of receipt of a certified copy of the
Pension and gratuity also.
Huh?
Gratuity also.
pension and
Pension
gratuity.
and other.
Writ petition stands disposed of.
I have to do it.
May I please?
Yes.
Hello, Miss MD Bora is on legs. The matter may be passed over for the time being.
What is the matter about?
Lordship, the petitioner's father, Lordship, died in harness in the year 1990. Thereafter, Lordship, the petitioner was engaged as a master role worker the next year. And thereafter, as a work charge Khalasi after 2 years on 29/7/93. And thereafter, after a span of more than 10 years, he was, the post was regularized. He was regularized to a personal post in the year 2004. And since 2004 onwards, Lordship, although he is discharging his duties, Lordship, he has been performing all the duties assigned to a grade 3 employee without any promotion, Lordship. Notice has to go at this stage.
Notice, will issue notice at this. I heard Mr. Ramani and accounted for the writ petition appearance the amendments made in the writ petition. The petitioner herein is presently serving in a grade 4 post in the establishment of sub-engineer grade 2. Where is he serving now?
Inland Water Transport Department, Lordship. Guwahati Division.
Which establishment?
Guwahati Division, IWT, in Inland Water Transport Division.
In the establishment of Guwahati Division of IWT. According to the petitioner, although he is holding a grade 3 post, yet since the year 2004,
Yes.
he has been discharging
Grade
the
4
duties-
post.
Grade 4 post, yet since the year 2004, he has been continuously performing the job of a grade 3 category post. First up, although promotional posts are available, the respondents have not taken any initiative to consider the case of the petitioner for promotion to a grade 3 post. Hence this writ petition. Mr. J.K. Goswami, learned additional government advocate, Assam,
Respondent one.
and Mr.
RB Goswami.
R.B. Goswami, learned standing counsel.
I'm appearing on behalf of Assembly.
Miss M.D. Bora, learned standing counsel, IWT. The department have both prayed for some time for instruction in the matter. NOM 8 weeks since Mr. Goswami has accepted notice for respond number 1, and Ms. Bora for respond numbers 2 to 4. Service of notice given to be completing this case. Pendency will not be a bar for the authorities to take redress the grievance of the petitioner in accordance with law if so advised. Pendency of this writ petition.
Lord, the grievance here is, it is, it's a
Yes.
non-consideration of promotion, my lord. It reveals now, my lord, that from page 18, that the uncommunicated ACR, my lord, was taken into account. I was awarded good, whereas the benchmark is very good. But then in that case,
All right,
good is to be
Mr. B.
considered
Patel,
adverse, my lord.
Counsel for the petitioner. The grievance of the petitioner who is serving as Subedar Racket GD in the Assam Rifles is that his case was not considered by the authorities for promotion to the rank of Major Subedar. Full stop. Mr. Pathak submits that the petitioner was denied promotion on the basis of uncommunicated adverse entry in the ACR. Full stop. Mr. SSR and CGC prays for some time to seek instruction and file affidavit. NOM 6 weeks. Says Mr. Roy has appeared and accepted notice for all the respondents, no formal notice, extra copies. It is made clear that pendency of this petition shall not be a bar for the authorities to consider the grievance of the petitioner in accordance with law. In if so advised.
Obliged.
Please, Your Lordship. The petitioner is a constable of RPF. He's been found medically unfit for present category of job, and therefore, my lord, he was recommended for C level of job, my lord. And now, my lord, what they have done, my lord, they have posted me as a cook, where I have to stand on my leg, my lord, for a long period, which is not.
Other writ petitions are pending on the same point.
No, everything.
It will come, others are pending, will come on Monday.
No case is pending. I have filed fresh. Earlier I have withdrawn, my lord, due to some technical.
All right, we'll just issue notice at this stage. Not Mr. Aerofik, any counsel for the petitioner.
My lord, I have already been spared, my lord. I have already been spared, my lord.
Spared means?
Spared means, my lord,
Discharge from,
not discharged, my lord.
relief from the
Relief.
earlier post.
Correct, and now you are working as a cook.
Not,
No, I am not
not-
joined, my lord,
not
because
joined.
It's not possible for me, my lord, to join as a cook.
All right, so we'll examine it. All right. Here is the government made in the writ petition. The petitioner herein was serving as a head constable under the Railway Protection Force. Due to some medical conditions faced by him, the petitioners, it was not possible, no longer possible for the petitioner to discharge the duties of head constable. Therefore, the authorities have assigned him the duty of cook, contending that due to the injuries suffered by the petitioner in his leg, it would not be possible for him to function as a cook. The petitioner has approached this court by filing this writ petition, contending that the authorities ought to, what do you want? Alternative,
Alternative job.
ought to have considered the case of the petitioner for assignment of any other duty which is in consonance with his medical condition. Full stop. Mr. SSR Leonard CBC appearing to the respondent's place for some time to open instruction of the matter. NOM 6 weeks since Mr. Roy has appeared and accepted notice for all the respondents.
All this.
No formal notice, extra purpose. Let us see, let them come up.
Obliged.
May I please, Lordship? Lordship, this matter has been disposed of before, Lordship. Lordship, may
Matter has already been disposed of.
Lordship, kindly come to page number 12, Lordship, annexure here, Lordship. The LCS recommend the case of the petitioner, but due to the OM dated 18/9, Lordship.
So
The-
we'll have it.
Lordship,
post-
at this stage, a premature case, Lordship, kindly see the prayer portion, Lordship, yes.
Hmm.
Lordship,
What is the prayer portion?
may I read, Lordship?
Hmm.
Would be pleased, petitioner has recommend, Lordship, middle portion, Lordship, would be pleased to readmit this writ petition issue rule calling upon a respondent so cause as to why the writ petition so and so forwarded the DLC district level committee Dhemaji bites its minutes dated 12/3/24, Lordship, and appoint, and after going through the so cause file, if any hearing, the parties be pleased to make the rule and absolute, Lordship. SLC not considered, Lordship. DLC recommended, Lordship, and otherwise a premature case, Lordship.
Lordship, on OM dated. 4th
He has not challenged this OM, Lordship.
So you have to challenge the OM.
Lordship,
Lordship, I have annexed this.
Yes, annexed,
No,
Lord.
annexed is not good enough. You have to challenge it. You have to ask for setting it aside. Otherwise, you can't
Lordship.
get compassionate appointment. So you withdraw and file a fresh. All right. Otherwise, this will be dismissed. Now there is a OM which says it cannot be appointed. So the relief you are paying is not permissible unless the OM is set aside. All right, your name, please.
Pay by.
Ms. A. Pine and counsel for the petitioner seeks leave of this court to withdraw this writ petition with liberty to file afresh by assailing the OM dated 18/9/2024 issued by the government of Assam. Mr. A. Chakraborty, learned government advocate Assam, and Ms. D.S. Nyog, learned standing counsel for the irrigation department, are present and do not have any objection with the result.
Obligation.
Any of the above, the writ petitions can dispose of and withdrawn with liberty of speech.
Look, this is then.
Lordship, we have the updated status report, Lordship. Everything has been done and the representation submitted by the present petitioner along with the inquiry and everything relevant documents has been placed before the competent authority, Lordship. And we are awaiting the final disposal, final consideration, Lordship.
No, but your awaiting could take months.
No, Lordship. 10 days.
This matter has been adjourned on a number of occasions.
1 week হবে না? 22. Never getting located.
So you are challenging what, the order of,
Basically suspension.
where is the order?
2 years, the order of suspension, my lord, will find in the writ.
Hmm.
Page. Nine to 2023. And page number, my lord, will find
9/3.
9 2.
Ninety-two.
9 February, my lord.
Now, what is the page number?
Page 88.
Page 88. It's
And
So
since
what
then-
is the order you want today? See, they have said the charge is established. You put pressure, it will be an order of dismissal. We'll ensure that it happens. Do you want that?
the
See, what happens is once the authorities say the charge is established, even if the order of suspension is set aside.
Yes.
There has to be some timeline to implement it. They will definitely dismiss your client. So this will be a futile exercise.
that your lordship expressed on the last occasion also.
Do you
But
want that to
here-
happen?
Lord, without going into whatever has been said by the inquiry officer, Lord, they are projecting a case before your lordship.
No, you are not understanding the.
I
We are
understand.
not going into what an inquiry of.
Fine, man.
These instructions says charge has been established and it is serious. If we
Yes,
push hard, they will dismiss you. In any case, they may, but if you push hard, they will definitely dismiss your client from service. Then this order will
ultimately,
become,
my lord,
this order will become redundant.
ultimately, my lord, for last more than 2 years, they are continuing with the DP. No purpose will be served. Some pressure has to be exerted upon them. There's
Right.
At least,
So we'll set aside the order of suspension, giving you 2 weeks time to pass final orders in the disciplinary proceeding. 2 weeks
Lordship, I am led by the Advocate General, Lordship. Today he is out of station, Lordship, and
That can't be, that can't be. We have taken so many cases, we have taken time.
Lordship
Courts
may
have
fix
to-
it till next week, Lordship.
Not possible.
Yes, Lordship. I think he may present or Lordship, he may.
No, that's, we can't say about it. Whether he. will be
Lordship,
present-
Monday or Tuesday, Lordship at least.
I am passing the final order in this case. You make your submission, you make your submission. And then the order will be passed. The court's proceedings have to have some clarity and some certainty. I think the matter has been adjourned twice or thrice already.
Lordship,
We can't go on doing this.
Lordship may kindly fix it on Tuesday, Lordship. I'm just praying, Lordship.
I'm rejecting that prayer.
Lordship.
Okay, your job is to make a prayer, our job is to either accept or reject. So yes, Mr. Das, please.
yes. The
9/2/2023.
is the first suspension, the suspension order. Then, my lord, kindly have the consolidated affidavit I have filed, my lord, incorporating the subsequent developments.
We are not going into it. Don't
I'll-
go here and there. I'll admit and fix it for hearing. The only question is your client has been placed under suspension on 9th February 2023.
Fine.
The order of suspension has been reviewed. Number of times it has been reviewed.
It was reviewed after completion of 90 days.
Okay. So only question is whether the order should sustain today or not. Don't go into what are the charges, what affidavit
No,
you have
I'll not
placed are
go.
irrelevant.
I was only pointing out the order of review to show that it was beyond 90 days.
Okay, where is the order of review?
Lordship will kindly have the consolidated affidavit I have filed
Hmm.
on 27/12/2024.
Can you give the page number?
Yes, my lord. Lordship will, the page number starts from 128. And the relevant order of review, my lord will find,
128, is it?
yes, the relevant order, your lordship will find page 149. Page 140.
149.
Yes, ma'am.
One forty-nine is para 17 of the affidavit. Dated 30th of December 2024.
No, my lord. There is a consolidated affidavit I have.
That's right, a consolidated affidavit.
Page
Sure.
number, annexure A1, my lord, of that particular affidavit.
Okay. And there is something wrong with the pagination.
My lord, my
Yes,
apologies.
may to Lordship.
My apologies.
Hmm.
Annexure A1, my lord. This
It's
is the,
159, not 149.
I'm sorry, my lord. I'm extremely sorry.
Yes.
This was the first review. It was done on 24/5/2023, my lord. Retrospectively with effect from 9/5/2023.
This 5, 7, 10 days here and there.
My lord, the Supreme Court says even one day, PM Bali's case, say 90 days over
my lord, the matter ends, the suspension goes. That is
Say on the 90th day, there is an earthquake for which the office cannot seek. On the 91st day is gone.
No, lordship will
Cannot be,
appreciate.
law cannot be.
There is some kind of requirement under which
That's
this
correct.
condition was
So if there
fixed.
is an explanation for not doing it within 90
There is
days.
no explanation. In the affidavit, there is no explanation. Not only that, my lord, then the second review,
Yes.
your
when is the
lordship will
second review?
find,
Page number,
second extension is at page number, annex A2.
A2 of the consolidated affidavit, is it?
Yes, my lord.
Hmm.
They have done right notification dated 10/8/2023 with effect from 9/8. Fine. Then third extension again after 90 days. Third and fourth extension that your lordship will find annexure A2 Coli dated 22/11/2023 is the third extension. And fourth extension is 19/2/2024. Both this third and fourth were retrospective beyond 90 days.
Fourth extension was 19th February.
Fourth extension was 19 February, my lord, with effect from 9/2/2024. That I have stated at para 7 of the consolidated petition, the dates and all. Same reason, gravity of the offense and embarrassment for the government.
Yes, so is it not a valid ground?
Gravity of the offense, my lord, lordship is correct that for the gravity of the offense, they can, my lord, place me under suspension. At that, on that count, my lord, your lordship, at least to have an understanding whether the offenses are so grave so that she can be placed under suspension more than 2 years. I'm not asking that your lordship will go into the nitty-gritty of the charges, my lord. At least to have a prima facie opinion whether, yes, the charges are so grave. Lordship has to see
Where is
only
the
one
charge?
document.
Where is the charge sheet?
Yes, my lord. Show cause, my lord, we find in the writ petition, it's annex, my lord. Page number 6, page number 82 of the writ petition. Annex 6. They have said so many things, my lord. I have given illegal appointment of so and so employees on contractual basis. But the moot question, whether I had any role to play, because I produced documents before your lordships to show that it was not me. It was the board of directors. And board of directors, the decision contained in the minutes I have placed before your lordships, which will clearly prove that I had no role.
All right, so we'll ask you to take a final decision within 2
Lordship.
weeks, failing which the order of suspension will lapse and she will be liable to.
Lordship,
That's the order will pass.
Lordship.
Yes.
Even if your lordships, but I'm not taking time if your lordships. Para 6 of the charge sheet, it's very clearly says that it is the BOD who has got the power to give appointment, and BOD's minutes I have annexed.
No, I understood. At this stage,
Exactly.
the court-
I understand, Milo. That's why, Milo, I said I don't want to waste the time. But that is the fact.
Only consideration is indefinitely an employee cannot.
Exactly. They cannot be-
Nothing beyond that, you
Nothing
may
beyond
not
that.
have, you may not have much to argue.
No,
on
no.
this.
My argument is precisely within that limit.
All right, I heard Mr. HK, that when counsel appearing for the writ petitioner, also heard Ms. Empathetic Healthy, learned additional senior government advocate Assam appearing for the state respondents. The while discharging her duties. Now, the writ petitioner hearing. She is an SCS officer.
ACS officer.
Is an officer belonging to the Assam Civil Service Grade 1, bracket SCS Grade 1. Full stop. During the course of her employment, the writ petitioner was appointed as the managing director of the Assam Fisheries Development Corporation. While discharging her duties as the MD of AFDC, detail put it in bracket short form, by issuing the order dated 9/2/2023, the writ petitioner was placed under suspension pending joint of departmental proceedings against her. First up. Thereafter, now the pending departmental proceeding initiated against her. First up, on 9/2/2023 itself, a show cause notice under Rule 9 of the Assam Services bracket Discipline and Appeal Rules 1964, read with Article 311 of the Constitution of India, was served upon her, calling upon the petitioner to show cause as to why any of the penalties prescribed under Rule 7 of the Rules of 1964 should not be imposed upon her. First stop. The inquiry conducted into the charges brought against the petitioner has since been concluded, and the inquiry officer has also submitted the inquiry report. Full stop. It is the admitted position of fact that a copy of the inquiry report was forwarded to the petitioner. Thereafter, she has also submitted her response in respect thereof. Full stop. The disciplinary authority is, however, still to take a final decision in the matter so as to bring the disciplinary proceeding to its logical end. Full stop. In this writ petition, the basic plea of the petitioner is that there were lapses on the part of the departmental authorities to review the order of suspension within the time frame laid down in the decision of the Supreme Court rendered in the case of Ajay Kumar Chaudhary and Union of India reported in so and so, as well as the subsequent decision of the division bench of this High Court rendered in the case of State of Assam versus Ajit Kumar Sonowal, reported in so and so.
2023 6 GLP 115.
You give him the citation.
Here, I'll give you.
According to Mr. Das, if an order of suspension is not reviewed within the time frame of 90 days from the issuance of the same, the said order would lapse automatically by operation of law, and the same cannot be revived beyond the period of 90 days by granting it a fresh lease of life. Viewed from that angle, submits Mr. Das, the continuance of the writ petitioner in suspension as on date is wholly illegal and therefore is liable to be set aside by this court. Full stop. Ms. Bhattacharjee, learned additional senior government advocate, Assam, on the other hand, has produced a copy of the written instruction dated 4/4/2025, issued by the Joint Secretary to the Government of Assam, Personnel bracket A Department, to submit that the charges brought against the petitioner have been established in the inquiry proceeding. And after receipt of the representation of the petitioner on the inquiry report, the disciplinary authority is contemplating to take appropriate decision as regards the penalty that ought to be imposed upon the petitioner in the matter. Full stop. Since there is a possibility of imposition of a major penalty upon the petitioner, any order for reinstatement of the writ petitioner in service would be detrimental to the interest of the department and also embarrassing for the government. Under such circumstances, Ms. Bhattacharya submits that since a decision by the disciplinary authority is expected in a matter of weeks, no order be passed in the present proceeding as per the prayer made by the petitioner. Full stop. Petitioner, even if a technically sound case is made out by her. Full stop. I have considered the submissions made at the bar and have also gone through the materials available in record. It appears that the petitioner was placed under suspension at that time. She was working as MD of AFDC.
No. She, my lord, at the time of, she relinquished the post, but I'll just give the date, my lord. Prior to that, my lord, she relinquished the post. She handed over the charge of the post of MD on 15/12/2021. She was not working as MD, my lord, anymore.
It appears that the writ petitioner had discharged the duties of Managing Director, MD of AFDCL during the period from, you have to give me the period.
12/3/2020
12/3/2020
to 15/12/2021.
15/12/2021. Full stop. Thereafter, she was posted as Joint Secretary to the Government of Assam, Border Protection and Development Department.
Yes.
Full stop. Full stop. On 9/2/2023, the petitioner was placed under suspension pending trial of departmental proceeding, pending initiation of while the petitioner was serving as MD of AFDCL, certain anomalies pertaining to regularization of employees and appointment of contractual employees in the AFDC were detected while the writ petitioner was the Managing Director of AFDCL. As such, a departmental proceeding was initiated against her in terms of Rule 9 of the Assam Service Discipline and Appeal Rules 1964. By the order dated 9/2/2023, issued under Rule 6, bracket 1, bracket close, bracket small a, bracket close of the rules of 1964, the petitioner was placed under suspension. Full stop. The order of suspension was thereafter reviewed on 24/5/2023, then again on 10/8/2023, and then on 22/11/2023, and finally on 19/2/2024. Thereafter, there has been no review of the order of suspension. Full stop. In the meantime, the disciplinary proceeding initiated against the petitioner had ended in submission of inquiry report, whereby the charges brought against the petitioner were held to be established. After obtaining the response of the petitioner pertaining to the inquiry report, the disciplinary authority is contemplating imposition of major penalty upon the writ petitioner. It is in these factual backdrops, this court is called upon to consider as to whether this is a fit case for interfering with the order of suspension dated 9/2/2023 on the ground that the departmental authorities have failed to review the same within the timeline prescribed by the decision of the Supreme Court as well as the High Court in this regard. Next paragraph. The Honorable Supreme Court has time and again emphasized on the need of the authorities to dispense with prolonged suspension of employees pending departmental proceeding system. It has been held that an employee cannot be indefinitely placed under suspension pending trial and or conclusion of departmental proceeding. However, in order to lay down a proper framework for the authorities to deal with the order of suspension, it was observed in para 21 in the case of Ajay Kumar Chaudhary Supra as follows. Quote para 21. Following the decision of Ajay Kumar Chaudhary, this court in the case of Ajit Kumar Sanwal, bracket Supra, had made the following observations in para 13, which is reproduced here in below. From a careful analysis of these two decisions, it is thus crystal clear that an order of suspension, if not reviewed and or extended with proper reasoning within 90 days from the date of issuance of the order, would automatically lapse by operation of law. Viewed from that angle, there can be no doubt about the fact that the order of suspension issued to the petitioner had lapsed. Viewed from that angle and by applying purely technical yardstick, there can be no doubt about the fact that the order of suspension of the petitioner had lapsed due to failure on the part of the had lapsed. What would be the 90 days after 8/2/2023? 8/2/20. On 8/5/2023, due to failure on the part of the respondent authorities to carry out review of the same within the period of 90 days from the date of issuance of the same. First of all, in view of the law laid down in the case of Ajay Kumar Chaudhary and Ajit Sonwal, such order of suspension would not have been given new lease of life by giving it retrospective operations after the date on which, by passing an order after the lapse of 90 days. First of all. At the same time, this court is conscious of the fact that placing and or continuing an employee under suspension, pending trial of conclusion of a departmental proceeding lies in the realm of the executive, and unless their action is found to be wholly unreasonable and in contrary to law, the writ court would ordinarily not interfere with such decision. First of decision, provided it is established that the right of the employee is not unduly prejudiced due to prolonged pendency of departmental proceeding and or continuance of order of suspension. First of coming to the facts of this case, there can be no doubt about the fact that the department disciplinary proceeding initiated against the writ petitioner pertains to charges which are quite serious in nature. Whether the charges have been established, cogently established, based on relevant materials or not, is not the subject matter of this writ petition and can be gone into at an appropriate stage as and when the occasion arises. What would, however, be topical for this case is as to whether in view of the decisions referred to above, the petitioner can be continued in suspension pending decision of the departmental authority without a definite timeline. The answer to this said question would obviously be in the negative. Question. In view of the above, and considering the prayer made by Ms. Bhattacharya that within 2 weeks from today, the disciplinary authority will take a final decision in the matter, this writ petition is hereby disposed of by granting 3 weeks' time from today to the departmental authorities to pass final order and bring the disciplinary proceeding initiated against the petitioner to its logical end. First of logical end, failing which the order of suspension dated 9/2/2023 as extended from time to time shall automatically stand quashed on the expiry of 3 weeks from today. Full stop. In such an eventuality, the respondent will be duty bound to reinstate the petitioner regardless of the gravity of charges. In such an eventuality, regardless of the gravity of charges, the respondent authorities would be duty bound to reinstate the petitioner in service within a period of 1 week thereafter. Full stop. It is, however, made clear that the order passed in this proceeding does not in any way. No, the order passed today in this proceeding would not in any way have a bearing on the decision of the disciplinary authority pertaining to the departmental proceeding initiated against the petition. The writ petition stands disposed of accordingly.
Lordship, regarding this 90 days period, Lordship, if from the date of suspension, if the charge sheet is filed within 90 days, Lordship, we have our one OM of 4 February 2020, where it is stated that 6 months time period is granted for review of the order. And this OM has been passed upon the direction of this series of matters decided by this honorable court.
Then you have to seek review of Ajit Sanwal.
In fact, that OM also says, my lord, if
No.
the memorandum of charge is served within 3 months, suspension, region order must be passed for the
Yes.
extension of the suspension.
Within 6 months. This is 6
3
months.
months, it says.
6 months, Lordship, this is there.
First para, last to serve.
Then let's read the third para.
All right, then you seek a clarification of Ajit Sanwal.
Exactly.
Lordship,
What is the date of this OM?
4th February 2020, Lordship.
And Ajit Sanwal came after that. Yes,
Yes. 2023, my lord.
then you have to seek a clarification.
Lordship.
That was not placed before the court.
Lordship.
You have to seek a, but in any ways, you have everything now, you
Lordship,
take a
that I
decision.
understood, just I place, Lordship.
One small factual correction, my lord. In their communication, which has been placed by them before your lordship today, there was no mention that they are going to impose major penalty.
They are going to impose penalty
They are going to impose.
under 7,
My lord,
under section 7.
they don't say, my lord. They have initiated the proceeding.
Hmm.
Major,
Measure card you cut.
my lord, that's fine. That much only. Fine. Much of it. Deeply okay.
The IS stand disposed of and contempt case also stands. closed.
Yes. Citation to that.
May I please, your lordship? During the pendency of this writ petition, my lordship, the petitioner expired, my lordship. So we have filed an IA, my lordship, for
Where are the legal errors? Where have you given the names and particulars of the legal errors?
lordship?
The applicants are the legal heirs.
Yes, my lordship.
Take down hard Mr. P. Any objection?
No, man.
Hard Mr. P. S. Rajalani, counsel for the applicant. Also hard Mr. R. Dhar, Learned Standing Counsel, Handloom and Textile Department. Assam, as well as Miss
S. Sharma on behalf of B. Sharma for respondent number 6. Right. Okay, Chairman.
As well as Ms. B. Sharma, Learned Counsel, appearing for the respondent number 6. Mr. Dhar for respondent numbers 1 to 5 and Ms. B. Sharma. You are for? अच्छा डिटेल लेने के लिखो Mr. Dhar for respond numbers
1 to 4 and 5, my lord.
1 to 4 and 5. Miss
I am Barwa.
R.M. Barwa for respond number 3 and Miss M. Sharma.
S. Sharma.
S. Sharma for respond number 6. All right. The two applicants herein are the legal heirs of deceased Parul Devi, who was the writ petitioner in WPC number 4189/2024. Late Parul Devi expired on
30/12/2024, my lord.
when did she expire?
30/12/2024.
30/12/2024 by leaving the applicants behind as her legal heirs. Mr. Raja submits that this IA has been filed with a prayer to substitute the applicants as the legal heirs in the original writ petitioner in WPC number 4189/2023. The learned counsel for the respondents have submitted that they would not have any objection if the prayer is allowed. In view of the above, and after taking note of the statements made in the IA, the prayer for substitution is hereby allowed. The two applicants hearing shall be substituted in place of the writ petitioner in the connected writ petition as her legal heirs. Mr. Raya to file amended cost title within 2 weeks from today. Let the writ petition be listed thereafter for necessary orders. IA stands disposed.
Obliged.
I think well.
May I please, Your Lordship? There is a IA for correction of the cost title, my lord.
Correction of?
In the cost title, my lord, the serial number of respondent number 2 has been wrongly typed as 3. And 3 has been typed
No, what are you seeking? Correction of what?
cost title.
Cost title of?
Cost title of the respondent number 2.
Cost title of what?
Writ
Respondent
petition.
number 2 doesn't have a cost title. Writ petition.
Writ
has.
petition.
You have made the mistake.
Yes.
You cannot seek correction like this. You have to seek amendment.
Amendment petition.
Yes. Oh, you have any objection?
No, Lord.
Mr. I. Rafiq, learned counsel for the applicant, also heard Mr. H. Chakravarti, learned B. Assam, appearing for the respondents. This IA has been filed with a prayer to amend the cost title of the writ petition on the ground that there is some typographical mistake in mentioning the address of
The serial number of respondent number 2 and 3.
serial number of respondent numbers
2 and 3.
in arraigning the respondent numbers 2 and 3 by projecting their correct serial number. Full stop. Mr. I have perused the statements made in the IA. Mr. Chakravarti submits that he would have no objection if the prayer for amendment is allowed by this court. In view of the above, and considering the submissions made at the bar, the prayer for amendment of the writ petition filed in WPC number 1383/2025 is hereby allowed. The amendments be carried out in terms of the prayer made in this IA. Applicant to writ petitioner to file amended writ petition within 2 weeks from today.
And we have filed the amendment petition. This is the amendment petition. I.
No, where is the writ petition? You have to file the entire writ petition again. That's the law. Yes. Amended writ
Yes.
petition within 2 weeks by serving copy upon the respondent's counsel. Let the matter be listed thereafter. I stand disposed. You have to file a complete writ petition. Yes, that's all.